Yeah. 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 So many lies that you hear from the net, they don't get her respect. She reporting the truth, not a check. You want an unbiased opinion straight from the chest. Not a bit of accomplice or someone here for a check. Tune in, these are thoughts from a lawyer on a mission who goes so hard it's like she works on commission. Trolls in the comments might say she tripping cause they lack the knowledge. They don't know they missing. Got a couple current events that you like. Wanna know about law from the eyes. Tired of all these blogs running lies because their agendas are disguised. Tune in to the intellect, cause I'm sure y'all missing all the facts of the case that she steady is gifting. Someone here for the people, man, it's so uplifting. If you ain't subscribed yet, then you just omitting facts.
What's up, everybody? This is Pam Esquire, also known as Your Law Intellect. How many? I saw y'all in that chat earlier. You guys were on that YouTube court hearing. I know it was y'all. I said, these are these intellects in these comments. Man, I know you guys are glad that you guys stepped in and actually watched that hearing. I saw y'all. I saw y'all. You said, yep. Oh, baby. We got another one. Present. I said it's 13 in here. Usually it's just 2 of us watching it. You guys had it on your calendar. Oh, St. James, you missed it. You missed it today. Oh, you missed it. What? I am so sorry y'all missed it. I am so sorry. Jessica was in the house. You know, that's usually my chatting buddy on Instagram. Oh. Don't say that. You're not supposed to do that. So don't say that. Don't say that. Dang. Some of y'all missed it. Well, for all the ones that missed it, it's not going to be as good as the transcript, which I just might order because that's just how good it was. I am coming to you live from New York. So yeah, so I know it's a little dark in here. I don't know what's up with the lighting, but we're going to get through it. So I was on a plane early this morning. So some of the hearing I did miss, but I got on there for some of the good parts. Now I was there when Whitehead testified. So for those of you that don't know what I'm talking about, Whitehead has a building that is in Connecticut. He was bragging a lot about this building that he bought, saying that he owned the block. And let me see. I'm sure I have a video somewhere.
In the rain, y'all. Slowing down the rain, but we working. We are working, y'all. Working. Stairs complete. Whitehead Estates, y'all. Coming all together.
That is what he calls Whitehead Estate. Now, Whitehead Estates has been in foreclosure since sometime last year. So, according to the complaint, thank you so much. I appreciate you guys are starting out making me feel love. Thank you, Tyra. I appreciate it. So, where do I start? So anyway, let's do the background because we have a lot of new subscribers. Shout out to you guys. Please hit that like button. You guys did very, very well. I posted this earlier. I think I started out with 45 likes before I even came in here. So let's just keep the momentum. Subscribe if you haven't done so already. I hope you guys enjoy this video. So Whitehead Estates is a building in Connecticut. A foreclosure action was commenced, and there have been several hearings, and the hearings were related to the upkeep. So what the mortgage company or loan company, while this foreclosure hearing was commencing, they wanted to enter into a receiver. So they wanted someone to come in. The first time they asked for a receiver, the judge was like, yeah, nah, basically, and we'll wait until it's not an emergency. They try to do it on an emergency basis. The judge said, no, you can't do it on an emergency basis. But as you guys see from my previous video, a couple of videos ago, I don't know how many, we talked about the Connecticut Properties and did an update that there was another motion that was filed. And so let me tell you about what receivership is. So I had one of the intellects emailed me and told me that that's what their job used to be. So they essentially said this, and I hope you guys pick up what I'm throwing. So they were like, the court appoints the receiver, which could be an attorney or a law firm. The receiver then hires a management company to come in to run the day-to-day and other things. All depressed properties have a goal of basically becoming self-sufficient so they can be for sale. So a funding company is then assigned and the inspection process begins. Upon the completion of the inspection, the report is sent to the funder and the court-appointed receiver. So then they have blind bids that are then collected and the best contractors are hired to cure the defaults. In the meantime, the management company will collect the rents and any additional monies needed to bring the property to a saleable condition. That comes from the person who the funder is. Then they have a final inspection will be conducted. Then all the reports are completed and then there's a possible sale. So once the property is self-sufficient, you get offers for the sale that are sent out and the mortgage company will try to get their initial investment back and the funders and management company will close their paid contracts out. So I hope that makes sense. So what they were trying to do was get a receiver in because this property, there were allegedly fire violations and there are other housing code violations. So if you guys recall, we'll go back to that document. I'm sure I have it. Of course I have it. We have the affidavit from the attorney. Okay, let me see. This before we get into this testimony, I got to give background because I need to make sure that it makes sense when we start discussing the actual testimony. Okay. We're going to focus, y'all. We're going to focus. So this is an affidavit. This attorney Swanson, is the attorney for the mortgage company or the loan company that loaned Whitehead the money for this building. It was like $4 million to get this building. So he tries to file an emergency motion. And so he basically says, as you see, I'm an associate attorney with McCarter and English LLP, counsel for the plaintiff, FM Home Loans LLC, as the above caption action. As such, I am fully familiar with the facts and circumstances set forth below based on my personal knowledge. On or about January 17th, 2023, Judith Rothschild, the director of Blight Remediation and Housing Code Enforcement for the city of Hartford, contacted plaintiff's counsel to inquire when the court would appoint a receiver in this action in the effort to resolve code violations at the subject property commonly known as 150 to 180 Earl Street in Hartford, Connecticut. And then they attach an email, which we went over in that video, from Ms. Rothschild to plaintiff's counsel. On March 3rd, 2023, Ms. Rothschild sent an email outlining the failures of the defendants, Whitehead Estates LLC and Lamor Whitehead, to comply with the City of Hartford's municipal codes and continuing violations of the property. And a true and accurate copy of the statement provided by Judith Rothschild is attached here too. Also on March 3rd, 2023, Ms. Rothschild forwarded an email chain between herself and defendant Lamor Whitehead dated August 2022 to February 2023, wherein Mr. Whitehead failed to cooperate with or provide access to the Hartford's Division of Blight Remediation and Housing Code Enforcement and Division of Building and Trades. A true and accurate copy of that email was also provided, and it was attached to the motion. So essentially, what the plaintiff was doing was trying to get an emergency meeting saying, hey, these people from the Housing and Code Enforcement, they said they've been going back and forth with Whitehead via email. He's supposed to be, he wants to be there when they inspect it, but they can't get dates, for them to show up. And they were showing a chain of emails of them trying to go to inspect the property. And allegedly, I guess, he was being uncooperative according to the Rothschild person. So they asked for a hearing on an emergency basis. They, meaning the plaintiffs, based on this. They want to get a receiver in because they're trying to protect and preserve the property. In response, Whitehead's attorney filed, now we know this was scheduled for the 28th. That's how most of you guys knew that the hearing was even happening, because we told you guys that you could find this on YouTube. So apparently right before this hearing, Whitehead's attorney tried to file a motion for a continuance. He didn't want this to happen on the 28th. It was #denied. He said it was his fault. He wasn't prepared, whatever. Okay. That was the reason why and this is a Connecticut attorney. This is a whole nother attorney that he has for the Connecticut issue. Then his attorney files a motion for stay to try to stay these proceedings. That was denied. So apparently a lot of these motion hearings were occurring while I was on the plane. So I didn't hear like that. I just saw like the orders that were filed. But there were a lot of issues that the judge brought out during the hearing. So that's how I know that there were other things that occurred as well. So let me make sure you guys are, yes, get the likes up. I'm over here working. Let me check out a few comments. According to the state of Connecticut and the New Haven Register, Whitehead Estates LLC is a fraud. You know what? Tyra said, I'm praying the church is awarded back to the real owners. My birthday is April 6th. Okay. Jeff said, did they know he only had $9.99 in his bank account when they gave him that loan? Did he buy the property in foreclosure in the beginning? I cannot see him getting anything full price. When you listen to this, when I listen to this hearing, and if I forget anything, because I know it was a lot of intellects in that chat, I told my husband, I said, I bet you it's never nothing but about 3 of us on here. I said, I know it's these intellects in here soaking up all the testimony that they can get. Thank you, Johnny. I appreciate it. Yes, I am your social media attorney. So, oh my goodness. I don't know where he's filing. Did he refuse to answer any questions and say that he will not be bullied? We are going to get to that. Everybody. So, yes, please like, please subscribe if you haven't done so already. I'm going to have to remind you guys periodically because I need to get in this algorithm so all these other people can get some of this. And thank you so much, Raymel Buxton, for the cash app. I appreciate it. So hopefully you guys are caught up and know that this is the property that we are referring to. Let's see. I was trying to see if I had another video of the properties. No, I don't. So let's move forward to today. I hope you guys are caught up and I don't lose anybody because I want everybody to enjoy this commentary on this hearing. So this is the hearing for the receivership. So Mr. Swanson, like I said, who represents the loan company, of course, he goes first. So people were testifying on this hearing. So the first person was the first person I saw, and you guys can tell me if there were other people before this, was Judith Rothschild. She basically was the one that we just talked about in the affidavit. So Judith Rothschild is the director of the Blight Remediation and Housing Code Enforcement for the city of Hartford. She essentially testifies as to the code violations that are related to the property. You know, as we know, the block that the bishop owns, she's talking about those code violations. She also mentions that he doesn't have the proper licensing, and there's certain loopholes you have to go through, or certain hurdles you have to go through in assessments in order to get this licensing, such as you have to have the lead safe risk assessment and provide to them that it's lead safe. So that's like a prerequisite to getting a license. You know, you have kids, that's been linked to a lot of issues. So that's one of the prerequisites out of, many that they have. If the violations are if they find violations, then you have to correct them in order to obtain the licenses required. So the question was asked, has a license been applied for these 3 buildings? And she was like, it has not. Of course, I'm paraphrasing a lot of this stuff because I don't have the transcript, but I have a very good memory and I take very copious notes. So she basically said, in summary, with all the requirements applicable which have not been met, and with this consistent difficulty with communicating and setting up with Whitehead, with this new owner, is what she kept calling him, despite the many attempts, she was saying that she would leave it to the court's discretion, but she thinks whatever the fastest way is to get this stuff done, this stuff needs to be done because these people are at risk. There are a lot of emergency situations and these people are at risk. So then you had, he called himself Inspector 2. His name was Mr. Brown. And there was exhibits that were up that the attorney Swanson placed. And he basically was talking about how apparently there was an issuing of electrical permit at one time, and that's in their document system. So they were setting the foundation of how he had this document to show that there was a permit that was issued. And so that was one of the exhibits. And then he goes like down to page 2, and he says like a permit, the contractor applied and got the permit, and then he did an email canceling the permit. So essentially the permit that he had, there was, you're supposed to have emergency lighting on the egress for inside of the stairway, emergency lighting, like it's required to basically illuminate the area. So if you have a power outage, a lot of times if you go in buildings and they don't have the power, or if they have like fire alarms that go off or the lights go out, they still have the brightness over at the stairs. That's what that is. So that's supposed to be something that's a requirement. And so again, it was asked, well, was a permit, you said that the permit was canceled. Has a permit been issued since? And the guy was like, yeah, no. So those are briefly, I'm gonna look in the comments to anybody to see I forgot anything from those 2, because we really want to get to Whitehead's testimony, but I think it would behoove us to know what the city officials were saying as well. So you said, how does he brag about a property when it's a whole hot mess? All right. Okay, so she was the first. I didn't hear her whole testimony though. So if there's anything you guys think that I should discuss and tell everyone that didn't make it, that forgot about it or missed it, and I started to share the link to my page, but I told you guys I caught it in the middle of testimony, so I didn't hear all of it. So I didn't think about it till then. Then I was listening to it in the restaurant while we were eating. I was like, "Ooh, this is getting good." I didn't think it was gonna be fireworks. I was like, "Oh, this is about property, like a receivership. What's so great about this?" But so I'm gonna look and see if I miss anything. So I don't see that anybody feels like they, because y'all want to get to the good part. I know. Okay, and there was the no knock box for the fire department. Okay. Trying to make sure I don't forget anything. Yes, that did happen as well, where that's true. And I forgot to mention that they're supposed to be where the rails are. There's a separation. There's a certain amount of inches that you're supposed to have. I believe it was 4 inches apart, because the purpose is so small kids, when you have kids that are in the building, that they don't fall through or their heads don't get stuck. And apparently it was too dangerous the way it was. So that needed to be fixed as well. We can get the transcript, but how they have it is you're not supposed to record, you're not supposed to photograph, you're not supposed to do any of that. So what happened is during COVID, the public has a right to view these hearings. That's why it's a big deal when they have closed doors hearings in court. And so in order to rectify that, because we weren't having court in person, they started having it on Zoom. Sometimes you have some judges that I've noticed, they actually keep it up on YouTube, but for the most part, they don't. They just stream it, and it's recorded, but it's recorded for the court. So like I've requested some of the hearings that happened on Zoom via video from the court, but you're not supposed to record it. You're supposed to ask permission for the transcript. And so they stream it at that time, and then they don't hold. So like if you go to the court's YouTube page, and they got more likes. I was like, did you guys subscribe? They subscribed and liked to the courthouse. You won't see the video because they stream it, and you got to catch it in real time or you just can't catch it. Plus, for some reason, this Connecticut court, the few times that I've been on there, they always have some type of technical difficulties. It's always a glitch. It's always something happening. I'm like, why is it always something? So it was a part of it where it was like offline, it was frozen. There was one point where Whitehead, he took himself off the camera, and the judge was like, you got to stay on camera at all times. This is a court proceeding. And so, he came on. He was looking a little somber. Like, if I could have took pictures of his face, if you guys watched it, let me know if you agree. But to me, he was looking real, like, he kind of looked defeated on that hearing. So, and then there was another time where apparently he said he got kicked out, but the judge was kind of like, you can't, this is a hearing and you need to kind of stay in. So she was on it. He said it wasn't purposeful. He just got kicked out of the room. Yeah, you said today was glitchy. It's always glitchy. Like every time I've been on there, it's been glitchy. So then Whitehead comes on. So his attorney calls him. He said, Your Honor, I would like to call Lamor Whitehead. So Whitehead, essentially, I'm just going to tell you what he gave, because when you're on direct, you feel all comfortable. This is your attorney. So he gave his rendition. He essentially stated, as he said on prior occasions, that he purchased the property with all these violations. He mentions, I believe there was a warrant at some time for the previous owner's arrest for all of these violations. So he inherited this mess, and he's been working diligently. So he gives a litany of all the things that he's done to upkeep this property. He said, I've been working diligently on this property 24 hours per day. He said he spent thousands upon thousands of dollars on repairing this property. He spent, I believe he said $150,000 on an alarm system so his tenants can be safe. And he said it like whatever this alarm system, they're connected to the phone. So his tenants, some of this stuff was like, what? So his tenants can I guess maybe the video, kind of like the video ringtone or whatever, they have it on their phones. Then he says he has a 24-hour super that whenever something happens, they're there and they can do repairs. They have keyless entries into the building. He's just saying all the stuff that he's done. And I guess there were like a couple of apartments maybe that were inspected and they were more of cosmetics. But if you go back to the testimony of Rothschild, there were plenty of things, some violations or whatever that she felt was important that needed to be rectified. So you said keyless entry when the windows ain't got no glass. I'm just telling you what he said. He said they got keyless entries. They got all this. Y'all seen the building, right? I done showed y'all what this building looked like. Let me show y'all again.
In the rain, y'all. Slowing down the rain, but we working. We are working, y'all. Working. Stairs complete. Whitehead Estates, y'all. Coming all together.
Building of which he's saying that he put all of these different things for safety of his people. So thank you so much. Thank you. I appreciate it. And welcome to the family. Your family now. So yeah, so then he says essentially that he's applied for these licenses and he's just waiting on the approval to finish the building up. So I don't know, I guess that was contradictory to the other testimony, and you guys can help me that was watching the whole entire testimony. But for him to say I already applied, well, maybe I guess it wasn't necessarily contradictory. I don't know, because I think the other testimony was that there wasn't currently any. So what he's trying to say is he has applied for this licensing and he can't do anything until this licensing goes through. So it's almost like it's not his fault. It's the city's fault that he can't do all these corrections because he has to get the permitting to do what he needs to do. So he has to get the proper permits in order to move. However, I believe Rothschild testified that there was some construction going on despite the permitting. So it was a little confusing and convoluted, but this is his testimony. He basically said, hey, this building from before was horrible and came with all these problems, and I've made it a lot better. He's saying the repair that needs to be done only takes 1 or 2 days worth of 2 to 3 days or something like that in order to properly repair what needs to be done. Even though they've been doing this honestly for the last 6 months, been trying to get some type of receiver in. So he talked about how he had a deal. So then his attorney asked him to do a narrative. I knew the judge was going to kind of like cut him off because he was like, Mr. Whitehead, is there anything that you would like the court to know? So then he goes on about he doesn't want a receiver because this is his livelihood. This is how he feeds his family. He has a wife and he has 4 children. And he said, if the receivership happens, he's going to be destitute and his family's going to be destitute. So this is why he needs this, needs, I guess, the rents to come to him. I don't know, but he doesn't want the receivership in to do this collection because he's going to be totally destitute. This is how he lives. He doesn't know it's going to be detrimental to his family if they allow this to happen. I said, Lord. So then he says, then he goes into this diatribe about how, it's so many things I've had to do. When you give him the floor to talk, he was like talking. He said, there's so many things that I've had to do. He said, and the pipes have busted, and the judge kind of was like, okay, see, this is my problem with narratives. I'm surprised that they didn't object and say cause for a narrative, because this is what it goes on and on where you can say, what you want to say. So the judge objects and was like, do you got any more questions, basically, to his attorney? Because he's like, basically, he just talking, and this is a narrative at this point, and we need to like wrap this thing up. So I think his attorney may have asked, like, oh yeah, he started asking him, Mr. Whitehead, do you know how big the buildings are? And he was like, no, I don't. He said, well, and the judge kind of objected. And he said, well, is it accurate to say that it's about 10,000 square feet? Because and the judge objected. The judge intervened and said he doesn't know how many feet it is. So how big it is. So what are we talking about? So then he tried to rephrase, do you think it's as big as the baseball field? And the judge was like, that's improper. So then he kind of like moved on. So, baby, that cross-examination came. This is where I want y'all, excuse me, this is where I want you guys to really pay attention. So, Mr. Swanson says, you've testified that you purchased the property. How much did you pay for the property? Whitehead said, I don't remember. The attorney says, do you recall taking a loan out for the property? Yes. Well, how much? I don't recall. I just don't recall at this time. And this is like paraphrasing. I'm almost like word for word, because I really remember this in my head, not joking. He said, I don't recall. So the attorney says, do you recall if the loan was taken out for the repair of the property? And so his attorney's like, objection. This is beyond the scope of my direct. And the judge was kind of like, yeah, no. He testified to all the money he spent on this property, so it's within the parameters. He can ask it. So then he's like, Whitehead's like, are you talking about when I purchased the building? The loan was not taken out for repair when I purchased the building. So then the judge says, the attorney, Swanson, for the loan company. How many times have you been to the Hartford property since you purchased the property? Oh my goodness, a lot. I don't even know how many times. I've been there a lot. He says, would you agree that the apartments are in Hartford, Connecticut? He says yes. So then the clerk says, could you put up my exhibit? So this is the exhibit he puts up. Let me find it for y'all, because y'all seen it before. He says, oh, there it go, y'all. He says, this is it. So he says, this is the exhibit that he puts up. He said, what I have on the screen, he had the court take judicial notice, because this was a part of a prior motion that was already filed with the court. He says, this is the affidavit of Lamor Whitehead in support of his motion to dismiss. Well, I said, what is about to happen, guys? Why is he pulling up this man's motion? Because y'all know how I do. I pull up his own stuff too. So I was just like, well, what is he about to do? So then he says, Mr. Whitehead, will you read paragraph 4 for the court? He said, he's looking at the screen. He says, yep, I read it. The judge said, I think they want you to read it out loud, sir. So he goes down to paragraph 4 and he's like, I do not transact business within the state of Connecticut. I'm sorry, y'all. He said, I do not transact business within the state of Connecticut. I read it. It must be a typo. I said, what? The judge said, that's not the question. Sir, is that statement as written true? His answer said, no. He said, so then the attorney said, can we please scroll to the next page? He said, Mr. Whitehead, is that your signature at the bottom of this document? He says, do you see the notary? Do you understand what that means to sign it for? He says, yes, that's his signature. He said, do you see the notary? Do you understand what that means to sign in front of a notary? His lawyer says, objection, it's not relevant. The judge says, overruled, this relates directly to his credibility. He said, so then the attorney says, do you know, and the attorney is very calm. He's just very somber. Like, I honestly wasn't expecting what he gave. I was like, because he's just seen kind of go with the flow, passive, but dude shocked me. So he says, do you know what it means to sign under the penalty of perjury? He says, Whitehead says, I don't know how to answer that question because I didn't purge. My attorney sent this over. The judge says, sir, just answer the question. He says, yes, I understand. He said, Whitehead, Mr. Whitehead. He said, Whitehead, I see y'all over here laughing. I need y'all to just focus with me. He said, Whitehead, have you been convicted of a crime? He says, his attorney says, objection. So then Swanson says, the attorney says, I would offer this conviction. I would offer to this court to take judicial notice of his conviction for fraud and theft from which he was convicted in 2013. And basically it goes against his credibility and is in conformity with whatever the Connecticut rules is. This is in all of our rules of evidence where you can, somebody that's been convicted of theft and dishonesty. So the court says, go ahead, take judicial notice. Basically he said, you're overruled on your objection. So he says, Mr. Whitehead, have you been convicted of a crime? He says, yes. The attorney said, well, what was the crime? He says, grand larceny. The attorney says, well, was there any other counts? He says, identity theft. Yes, but I don't recall it off the top of my head because that was like almost 20 years ago. Attorney Swanson said, no further questions. I said, Lord have mercy. So then Whitehead says, almost tells his attorney, like, just, because he want to explain this whole conviction thing, right? So he almost is like saying, his attorney, he kind of wanted his attorney to go with that because after the cross, he can do a redirect. He can do a redirect. So he comes in and he's like, Patricia said that lawyer was on the bar. Listen, he definitely shocked me because I was like, what is he gonna do? This is just a hearing, boring. So then he says, so this is Whitehead's attorney. This is Whitehead's attorney. Question, when were these crimes? Whitehead says, these crimes were alleged in 2004. Check out, he said these crimes were alleged in 2004. So then the judge says, not when alleged, sir. When were you convicted? He says, 2008. And then he says, but I would like to explain it. The judge said, nope, just answer the question. I'm going to get to that. So he said, nope, just answer the question. He says, he said, this is his own attorney, right? So then he said, did you plead to those crimes? I see, it almost seemed like his attorney just didn't even know this, because the questions he was asking was like, man, one of the first rules that you learn, I always say one of the first rules, because there probably are some that are universal, but you never ask a question you don't know the answer to. And I think he learned that today. So he said, since then, he said, and you've paid your debt to society, didn't you? This is why his attorney, he said, yes. He said, since then, have you been arrested? Whitehead said, yes. The attorney was looking like, oh, wow. And then he said, well, what were those crimes you was arrested for? He said, that I was arrested for. This is Whitehead. That I was arrested for? That I was arrested for? Did you say convicted or arrested? The judge said, he said arrested. He was like, I don't have them in front of me right now. So then his attorney said, oh, we'll move on. And the judge said, no, you need to answer the question. Like, no, you need to answer this question. He said, oh, well, it was alleged extortion. But I don't know about all the stuff that's in the indictment. Thank you so much, Tammy. I appreciate it. He said it was alleged extortion, but I don't remember all the other stuff that's in the indictment. He said, so his attorney said, but you weren't convicted of those crimes, right? He was like, no. I mean, the indictment, you ain't even have been tried yet for it, but nevertheless, he said no. So then he said, sir, what do you do for a living? What do you do for work? He said, I'm a pastor and I'm into real estate. He said, okay. So then he went back over the whole oath thing, because you seen what the other attorney did with the whole, how you saying that you don't work in Connecticut, but then you saying you spend all this time in Connecticut. You seen the video, we working, you doing all this stuff, and then you turn around, oh, I just signed what my attorney told me to sign, like you didn't even read it. So he said, you understand the oath today, don't you, Mr. Whitehead? He said, yes. He said, and your testimony today was truthful, is that right? He was like, yes. He was like, yeah. So when he said, let me back up. So when he said that it was extortion and he don't remember the other charge, the judge came in and was like, is it true? No. Maybe it wasn't the judge. It might have been the loan company. So I think it was the loan company came in and said, he did his recourse and said, is it? No. He said one of them, it was either the judge or it was the attorney. I don't want to mix it up. But he was asked, is it true that you're currently under indictment in the federal court of the Southern District? And he was like, this had to be Swanson, now that I'm thinking in my head. So Swanson said, is it true that you're currently under indictment in federal court of Southern District? So of course his attorney objected. And then he said, the judge overruled it, and he was like, well, what were those crimes for? He said, and then the judge overruled it, and Swanson said, and you were convicted of crimes for representing yourself as the businessman with connection with the mayor, with Mayor Adams, like you can, some connections. And he was like, basically, no, it wasn't true. And he was like, and then the judge said, that's when the judge came in and said, are you under indictment, sir? And he was like, yes. So Whitehead, by this time, he probably just couldn't believe that this just went far to the left the way that it did. Yes, Swanson was on it today. And another thing, apparently, I guess, allegedly, it was something with his address where, and this is what was brought up about his address. So when you come into their courtroom on Zoom, because it is a Zoom hearing, it's just going on YouTube. So when you go on Zoom, they make you state your name for the record and spell your last name, but you also have to say your address. So when he comes in under oath, I guess he said he gives the Paramus address, but at some point he must have said he didn't live there, and that's why he wasn't served or something of that nature. So in closing, of course, they were able to do closing argument. And when they did closing argument, basically Swanson was like, we don't even have to rely on his past convictions or his current indictment to know that he don't tell the truth. We can just focus on the untruthfulness he done told this court today. And so he said he claimed he didn't live at the address he was served at, but yet the court told him to give his address, and that's when he gave that Paramus address. He said just from the testimony that they've heard, the mortgage, he doesn't recall anything. So I know this is going to be a protracted litigation, and the purpose of having a receiver is to protect and preserve the property, especially when you're going to have that type of protracted litigation, which is basically it's going to take a while to get through. So that's pretty much why a receiver is necessary. So Whitehead's attorney comes back and he talks about, and I believe this was in closing. I believe he did mention this in closing, where he says, essentially, the prosecutor for the New York case is in jail for witness tampering. So he believes that that's fruit of the poisonous tree or something. He said, I'm like, sir, what are you talking about? So what it is apparently it wasn't the prosecutor that was specifically on his case. It may have been maybe the head prosecutor, because that name didn't sound familiar that they keep talking about in his transcript. So he was eventually indicted for something that had nothing to do with Whitehead's case. But he's using that as a way to say, like, hey, I was railroaded on top of, I was illegally convicted, and they had legal signatures, and they used the stamp, and the search warrants wasn't right, and they withheld evidence from my attorneys and all of that. He was trying to get into that, and the judge wouldn't let him get into it, because he was like, I would like to explain. The judge was like, no, you can't. So basically, his attorney tried to make it as if his credibility shouldn't be an issue, because he said, I guess it's like fruit of the poisonous tree because of who the prosecutor was. I don't know where he was getting at that, but all I could say was clearly that attorney probably don't know what's going on. So I was like, wait, what? The fruit of the poisonous tree? We going into evidence, the suppression or whatever? So anyway, I don't know. It was crazy. So he goes and he talks about a 2-prong test, and he claims that the plaintiff didn't satisfy the prongs, and that because they didn't satisfy the prongs, he said that there's only minor things that need to be done, or things that need to be done in a couple of, it only takes 2 to 3 days. He's already put in all of this money into the property, and so therefore a receiver shouldn't come in, because he's doing all that he can. He's done so much to this property, mentions all of the violations and all of that, and that basically the court shouldn't enter it into a receivership, because he's done so much for this property. And let me see if it's anything else on it. So essentially, everybody's asking, like, how was it concluded? The judge basically took it under advisement, which means that she's probably going to render an opinion based on all of that, because they did take testimony. So she'll probably specifically quote testimony on whatever decision that she makes. And of course, whenever that order comes down on whether it goes into receivership, we'll know. Which all of this is just crazy to me, because you still owe this money allegedly on the property. This is a foreclosure case. And why would you even want to put all this money in property that you may lose? None of it's like clicking for me. Maybe you guys can help me, because it doesn't even make sense. I'm like, why would you fight over property? Right, exactly. None of that's making sense for me. So I'm like, y'all help me. Thank you. He Thank you, baby Dow Owen. So of course it doesn't end there, guys, because it's never an easy thing. Apparently, immediately there was a motion filed by the plaintiff to dismiss the case based on the foreclosure. Now, all this motion in these hearings is for receivership. They filed something to try to do a motion to dismiss on the actual foreclosure. And that was filed today. So while we're here, we might as well, go over that real quick. You can't say I don't keep y'all informed on all of these shenanigans. So this is plaintiff's memorandum of law in support of the motion for summary judgment. So they essentially say, as fully set forth herein, plaintiff is entitled to foreclosure of its mortgage as it has established its prima facie burden of proof. So this is an action to foreclose a commercial mortgage against the real property commonly known as 150 to 160, 170 to 180 Earl Street, Hartford, Connecticut, and to enforce the related guarantee. Plaintiff now moves for summary judgment. To obtain summary judgment in a mortgage foreclosure action, the movement must show that it is the owner and holder of the note and the mortgage and that the mortgagor has defaulted. Here, the undisputed material fact established that 1, plaintiff is the owner and holder of the loan document as defined below. 2, defendant Whitehead Estates LLC, the borrower, executed the promissory note. And 3, borrower has defaulted on its loan, and as a result, plaintiff accelerated the full outstanding balance due thereunder. 4, borrower failed to pay the amount owed to the plaintiff. 5, borrower's principal, defendant Lamor Whitehead, and together with borrower, the defendants, personally guaranteed the borrower's loan. 6, Whitehead also failed to pay the amounts owed to plaintiff. And 7, defendant's special defenses are baseless. Accordingly, plaintiff is entitled to summary judgment as to liability on all counts of its complaint, and its motion should be granted. So this is information on the loan document. So on or about December 10th, 2021, plaintiff made a loan to the borrower in the original principal amount of $4,150,000 as evidenced by a certain promissory note. And then it has all of the parts that, we can read those. Borrower would pay to the order of plaintiff the original principal amount of 4.1 plus interest on the unpaid balance at the fixed rate of 6% per annum and monthly installments, with all unpaid principal and interest being due on January 1st, 2052. An event of default would include borrower's failure to pay any amount due under the note, borrower's failure to perform or observe any other term or provision of the note with respect to payment, or default under the related open-ended mortgage deed and security agreement. Upon the occurrence of any event of default, plaintiff could accelerate payment thereof. In any event, borrower failed to repay his debt in full, exercise its right under the notes. The same day to secure repayment of the note, borrower executed an open-end mortgage deed and security agreement pertaining to the property, including the building structures, fixtures, and all other improvements located thereon, which was recorded on December 16, 2021 at page 1 of the Hartford, Connecticut land records. That's another thing that Swanson was saying. You keep saying it only takes 2 to 3 days, but you've had this property since December of 2021. And also we took you to court since about 7-8 months ago, and we've been trying to do this receivership for like 6 months when we first filed it, and you still ain't done nothing. So why are you making it seem like you can just do a lickety split now? So then it talks about what the mortgage specifically states when in the event of a default. So Whitehead, the borrower's principal, also executed a personal guarantee of payment. So he personally guaranteed this $4 million debt with regard to the loan. Pursuant to the guarantee, Whitehead absolutely, irrevocably, and unconditionally guaranteed plaintiff the full, prompt, and unconditional payment of the loan, whether by maturity date, acceleration, or otherwise. The guarantee further provided that Whitehead would ensure the prompt and unconditional performance of each and every term and condition of every transaction to be kept and performed by borrower under the note. As of February 28, 2022, borrower and plaintiff amended the original loan document to increase the principal amount of the loan to 4.5. What? So y'all took it out on December 2021, and then you increased it and gave them a couple more dollars for 4.5. Buy-in through borrower's execution and delivery of an amended and restated promissory note in substantially the same form as the note, and it had basically the same type of terms. Borrower defaulted under the loan document by failing to make the monthly payment due and owing on June 1st, 2022. Or any payments that became due and owing thereafter. So he hasn't paid according to them since what? May of 2022? Borrower's failure to make payments constitute an event of default under the loan document. Although not required by letter dated July 25th, 2022, plaintiff notified defendant that an event of default had occurred, that the loan was being accelerated, and defendants were required to pay all outstanding amounts due and owing under the loan documents. Defendant did not make the required payments. To date, the event of default has not been cured by the borrower. The default rate prescribed under the loan document has been instituted, and the plaintiff has incurred and continues to incur significant expenses in connection with its enforcement of the loan document, all of which are recoverable under the mortgage. So the foreclosure action, plaintiff commenced the instant foreclosure action on or about September 2nd, 2022 by the filing and serving of summons and complaint with the return date of September 20th, 2022. On October 12th, 2022, defense counsel appeared on behalf of both defendants. Plaintiff now moves for summary judgment. So then it says that they are entitled to summary judgment. They go through what is required for a summary judgment. Let's see. They got a lot on summary judgment. So then they say here, the undisputed material facts establish that 1, plaintiff is the owner and holder of the loan document. 2, borrower executed a promissory note. 3, borrower defaulted on his loan, and as a result, plaintiff accelerated full outstanding balance due thereunder. 4, borrower failed to pay the amounts owed to plaintiff. 5, Whitehead personally guaranteed the loan and failed to pay the amounts owed to plaintiff. And 6, defendant's affirmative defenses are baseless. Accordingly, plaintiff is entitled to summary judgment as to liability on all counts of its complaint. Its motion should be granted. And then their argument is plaintiff is the owner and holder of the loan document and borrower has defaulted on the loan. As explained above, to establish its prima facie case for summary judgment, plaintiff must show that it is the current owner and holder of the loan document and the borrower has defaulted. And then it has the case law. Here, there is no dispute that plaintiff, the originating lender, continues to be the owner and holder of the loan docs. Likewise, there is no dispute that borrower defaulted on the loan by failing to make the monthly payment due on June 1st or any of the monthly payments that became due and owing thereafter. Borrower thereafter failed to pay the full amount of its accelerated debt as set forth in the notice of acceleration. The record is therefore clear that borrower has failed to make payments on the loan as required by the loan documents, despite plaintiff's demand for the same. Plaintiff has thus demonstrated that there is no genuine issue of material fact regarding borrower's liability in the loan docs and is entitled as a matter of law to judgment on the first count of its complaint. So then they have B, Whitehead is liable for the debt under the guarantee. Plaintiff is also entitled to summary judgment as it relates to the guarantee executed by Whitehead as alleged in the second count of the complaint. To establish a prima facie case for breach of written guarantee, a plaintiff must prove 1, it is owed a debt from a third party. 2, a defendant guaranteed payment of the debt. And 3, the debt has not been paid. You guys see the case law, and plaintiff has proven all of these elements. First, plaintiff is owed the debt evidenced by the loan documents from the borrower. Second, Whitehead guaranteed payment for that debt. Third, as a result of borrower's failure to make the monthly payment due on June 1st, 2022, or anything monthly payment that became due and owing thereafter, plaintiff accelerated the full outstanding balance of the loan, which remains unpaid. Pursuant to the guarantee, Whitehead unconditionally and absolutely guaranteed the prompt payment and performance of any and all obligations under the loan. Despite plaintiff's written demands, Whitehead has failed to pay his debt in accordance with the terms of the guarantee. Whitehead's failure to remit payment in accordance with the terms of the guarantee constitute a breach thereunder. Accordingly, after a foreclosure sale of property is held, and to the extent there is a deficiency, plaintiff is entitled to a deficiency judgment against Whitehead based on Whitehead's breach of guarantee. Oh, you might have another debt if they get this motion granted. Oh my goodness. not $4 million. Well, it'd be less than that because I'm sure they'll sell the building, and then he could possibly be obligated to any deficiencies. C, defendant's special defenses must be dismissed as a matter of law. Since plaintiff establishes prima facie case, the burden now shifts to the defendants to prove their special defenses in order to defeat summary judgment. As Connecticut's appellate court has explained, the party raising special defense has the burden of proving the facts alleged therein. If the plaintiff in a foreclosure action has shown that it is entitled to foreclose, then the burden is on the defendant to produce evidence supporting its special defenses in order to create a genuine issue of material fact. Legally sufficient special defenses alone do not meet the defendant's burden. And there's the case law. And it says the purpose of special defense is to plead facts that are consistent with the allegations of the complaint, but demonstrate nonetheless that the plaintiff has no cause of action. A valid special defense at law to foreclose proceeding must be legally sufficient and address the making, validity, or enforcement of the mortgage, the note, or both. And then it has the case law. Further, the applicable rule regarding the material facts to be considered on a motion for summary judgment is that the facts at issue are those alleged in the pleading. To the extent defendants assert the special defenses of, quote, mistake or accident, omission of parties, and insufficiency of service, they fail to plead or assert a single fact in support. Thus, as a matter of law, these special defenses are legally insufficient and must be dismissed. Defendants' blanket and baseless assertions of special defenses are nothing short of legal conclusions. Defendants have not asserted a single fact, allegation, basis, clause, or provision from the loan documents to support any of their purported special defenses, and thus fail to establish that their special defenses have a logical nexus to the making, validity, or enforcement of the loan. Defendant's special defenses are therefore insufficient as a matter of law. Accordingly, there is no issue of material fact that plaintiff is entitled to a summary judgment on its complaint. Wherefore, for the foregoing reason, the court should grant plaintiff's motion for summary judgment as to liability on all counts of the plaintiff's complaint. And there we have it, folks. So after the hearing, we're waiting on the judge to render an appearance. She's taking it under advisement to render, to render an opinion related to the hearings that some of us heard today. We're waiting. And in the interim, they must have came right up out of that hearing and was like, let me file this motion to dismiss this case on the actual underlying foreclosure case as well. So I'm gonna, yeah. Thank you so much, Bridget J. You say you make me want to commit a crime so I can hire you as my Don't do that. There are other areas of law that I could probably help you with that doesn't involve doing time. Sean said everything about him is fake. His bank account, the homes, the property, jewelry, church, real estate, robbery, them fake suits, but the jail cell is real. I hear you, Sean. So Andre says, I think we finally found the reason for the dog determination he's had to keep a GOG. He was trying to take possession, either sell or mortgage it to pay this loan. That's an interesting analysis. If he hasn't paid monthly payments for the loan in months, almost a year, the ball's on him that he thinks this is okay. Who's getting the rent payments? Well, there's already a receivership entered for the water company. I mean, it's a small bill. I think it's like $2,000, but I believe there's a receivership that the court has already granted, so they can get their $2,000 for some past water bill that he says that Whitehead has also argued that was a bill he inherited. Yeah, so y'all know I'll be back if we have any more new information. I hope you guys enjoyed the lives. If you guys enjoyed the lives, I said the lies. I guess them too. If you guys enjoyed the live, please hit those red hearts and let me know that you guys enjoyed the lives. Make sure that you hit the like and subscribe if you haven't done so already. Thank you to all the new subs. It was 730 something of you guys rocking with me today in the chat. I appreciate it. Jessica says the water bill was $8,046. Oh, okay, so you said my $2,000 was off. I got you, sis. I'm sorry. All right, I was guessing. Thank you. I thank you guys. I love each and every one of you guys. And y'all know I got to leave out with the new anthem that we got on here. But we'll be back. We know we got that hearing this week, and we'll see how the next thing goes. Oh, St. James said we got up to 779. That is what's up. All right, so let's hit this intro. We're going to make it our outro, and I'm going to holler at you guys next time.
Yeah. So many lies that you hear from the net, they don't get her respect. She reporting the truth, not a check. You want an unbiased opinion straight from the chest, not a bit accomplice or someone here for a check. Tune in, these are thoughts from a lawyer on a mission who goes so hard it's like she works on commission. Trolls in the comments might say she tripping cause they lack the knowledge. They don't know they missing. Got a couple current events that you like. Wanna know about law from the eyes. Tired of all these blogs running lies because their agendas are disguised. Tune in to the intellect, cause I'm sure y'all missing all the facts of the case that she steady is gifting. Someone here for the people, man, it's so uplifting. If you ain't subscribed yet, then you just omitting facts.